I would like to open the second panel of this morning. We will have 4 speakers at this panel, and they will present their views and arguments on a very heated topic. I think it's the topic of the day, and we can start from where Bruno puts us with his comment, and we will hear from 4 speakers, 4 presenters. They will talk about the regulation of legal practice, considering positives and negatives aspects of opening the market for legal services to foreign firms, and also stressing the economic and political consequences and aspects involved in this discussion. So from the 4 presenters, I would like to invite Frederico Almeida, who is from DIREITO GV and also a member of the GLE team, to start this panel. Thank you. And just to remind you that we will keep to the same rules as the previous. You have 10 minutes, and I will show you when we have 5. Do you?
Okay, thank you. Good morning, everyone. It's quite a pleasure to receive you all here at the FGV Law School, DIREITO GV, and I'm very glad to talk to you about this issue. Actually, I'm going to talk about a paper that has been produced by me and Paulo André Nasser, Master in Law and Development, and also researcher at GLE project, and it's part of this research project. Our paper aims at identifying and analyzing the regulation of the legal profession by the Brazilian Bar Association, which is called in Portuguese Ordem dos Advogados do Brasil, OAB, especially its politics and its policies facing new transformations of lawyering in Brazil. We choose that focus because of 2 main reasons. First, and in a different way of others bar associations, OAB was created in a corporative political context when the Brazilian state was able to directly organize many social groups under Getúlio Vargas' regime. OAB is until today a mandatory organization authorized by the Brazilian state to organize and control the practice of lawyers. Although its origins was directly connected to the Brazilian state, OAB achieved considerable autonomy and self-government capacities throughout its history. As you know, by the end of the 70s, OAB was considered one of the most important Brazilian civil society organizations, especially due to its struggle against the military regime. So I'd like to insist on the fact that OAB has a peculiar organizational and political model as a middle-term institution between the state and the society. The second reason is that the expansion of the legal education and the growth of the number of lawyers that has been taking place during the 60s deeply impacted the legal profession in Brazil. Apart from that, since the 90s, those processes were intensified by the opening of national market to global economy and by social pressures for different legal services and for new ways of conflict resolution. What was once an exclusive, small group of professionals became a large group composed by lawyers from different social origins, headed by professional elite. The old-style way of lawyering, based on the solo professional or the family firms specialized in litigation, has been replaced by employed lawyers in big law firms and by a diverse set of legal services, most of them focused on business matters and based on an advisory preventive approach. I'm not talking about a whole change in legal profession by distinction of the old-style lawyers. I'm talking, in fact, of new professional patterns existing alongside other traditional ways of lawyering. So I think here is the core of the politics of regulation, of professional regulation in Brazil. Those changes in the social and economic profile of lawyers brought new pressures over OAB and its regulatory capacity. Brazilian bar leaders have a long list of challenges. They have to oversee the employed lawyers' work conditions in big law firms. They have to ensure the minimum conditions of solo professionals to survive in a competitive labor market. They have to regulate the situation of foreign law firms acting in Brazil. They have to sustain lawyers' monopoly over traditional legal practices, and they must regulate new practices and demands brought by a globalized economy. And especially, they try to justify that lawyers are not business professionals in a competitive, money-intensive market of legal service. I think we must answer some questions if we want to understand the politics of professional regulation in Brazil. Can we find a pattern of OAB's regulatory interventions? Who are the relevant political actors, the main players, when a new professional rule is made by OAB to control the major law firms and their practice in the market of legal services? How the professional rules are enforced? We are still trying to answer those questions. And I'm sure that this event, this seminar, is an important way of doing that. Anyway, I think we must have clear that some controversial and recent regulation issues can help us to understand the recent changes in legal profession and the recent regulatory interventions by OAB. First of all, and it's not so recent, we must understand the regulation of new organizational forms of legal professions. I'm actually talking about the situation of employed lawyers, a new form of professional practice brought by the growth of the number of lawyers and by the diversification of the legal firm's structure. It's important to know that during the 70s and the 80s, OAB's efforts were all directed to keep professional autonomy even in a hierarchical relation, and in that period, Brazilian bar leaders were demanded to act as typical union leaders. But the rising of the employed lawyers is a phenomenon directly connected to other important phenomena. The rising of the modern Brazilian law firm, which is called Sociedade de Advogados, characterized by the hierarchical relations between major partners and associated lawyers and between those lawyers and employed lawyers. It also brings the idea of property of a law firm by the major partners. Those characteristics forced OAB to face new regulatory demands, very different from the situation of the well-known patterns of solo lawyer and the traditional law office, a horizontal informal association between autonomous lawyers sharing the same office. As I said, it's not a recent question. The model of law firm was first regulated by Lawyers' Statute, a federal act that organizes the legal profession in Brazil, in 1963. But only during the 90s, law firms became an important economical and political actor. The creation of CESA, Centro de Estudos da Sociedade de Advogados, is an important result of this process. We also have the situation of the foreign law firms. If the opening of national economy during the 90s was a trigger to the rising of the modern hierarchical Brazilian big law firm, it was also a strong appeal to bring foreign lawyers and law firms to Brazil. OAB has an internal rule called Provimento number 91, which states that foreign lawyers can act in Brazil in very restricted ways. Basically, foreign lawyers can act as advisors on foreign law, never on Brazilian law, just on their home country law. That rule also prevails that foreign lawyers can create law firms with the same restrictive goals. That rule does not prevail the possibility of association between Brazilian and foreign law firms. However, since the late 90s, many foreign law firms came to Brazil to work alone or in association with Brazilian law firms. Another important issue is the regulation of pro bono practices. Globalization can be understood as a cultural, symbolic process, regardless its economical and political aspects. In this sense, the model of the modern law firm in Latin America keeps many structural similarities to the North American model of law firms. and we believe that it occurs also in Brazil, even in apparently secondary aspects like pro bono practices. As you know, pro bono practice is a tradition of legal profession in the United States, and it's strongly encouraged both by law schools and law firms. Pro bono practice was introduced in Brazil during the beginning of the 2000 decade by the same major law firms that founded CESA, and they also founded the Pro Bono Institute. The major law firms, some elite lawyers, and Pro Bono Institute were responsible for the negotiations that resulted in a state bar's internal rule which allows pro bono practice just in case of advisory services offered for free to non-governmental organizations, the NGOs, with no resources to pay a lawyer. It's possible to identify other relevant issues that deserved OAB's regulatory intervention, all of them related to the increase of the market of legal services, to the rising of modern law firms in Brazil, and to the commercial business aspects of legal profession. That's the case, for example, of the Commission on Ethics statement about legal marketing and the possibility of paying lawyer service with credit card. Those aspects are apparently secondary and not so important, but they are core issues when OAB have to decide and to analyze the business and the non-commercial aspects of legal profession. So I hope this event and the seminar and the research that we are producing at the GLIP project can help us to understand those processes and the politics of professional regulation in Brazil. Thank you very much.
It's very important to have, but I'll try to counterpoint some of the statements that were made in this room this morning. First of all, I would like to say that this discussion and the debate nowadays is not a debate of a presence of foreign law firms in Brazil. The hot discussion at this moment is what is the freedom of Brazilian law firms to associate with foreign law firms. Just to make a correction, since the 90s, international law firms are not working in Brazil. Since the 90s, international law firms got interest by the strength of Brazilian economy. And that starts with the privatization during the 90s. I was not an international lawyer. I was not practicing global law during the 90s. I was in Rio de Janeiro while the privatization dynamics have established in São Paulo. By chance and fortune, São Paulo law firms had the opportunity to profit from this very special momentum of the Brazilian economy. And as very well mentioned in this room, old traditional, typical Brazilian firms could, in 20 years, become sophisticated, complex, and little giant law firms, kind of repeating the concept of global law firms or international US, UK law firms. However, what I can read today, looking at the past, institutionalization of this law firm were not a process that followed the strength and growth of these law firms in São Paulo. And it's not a regional issue. It's just the fact that this is the capital, economic capital of the country, where the things happen. And I just try to make a testimony of our example in history and how things went different, okay? So this traditional, and I would like to say parochial, traditional law firms in São Paulo could become sophisticated business law firms. And unfortunately, at that specific time, Rio de Janeiro was in pure decadence. And all of the financial institutions had moved from Rio de Janeiro to São Paulo. As a young lawyer graduating in law, I said, what is the future for a lawyer like me, graduating in 1988 with an 80% inflation rate a month? I said, either I should be a bankruptcy lawyer or a tax lawyer. I had absolutely no way and perspectives. But again, God is good, and people say that God is Brazilian. I would say God is Brazilian, but has a special look in Rio de Janeiro. And by chance, different from all sorts, in now place in the world where oil appears in very hard, remote, and an ugly place. The oil province of this country is very close to the sugar wolf and Christ regime in Rio de Janeiro. So that creates a very special and unique situation for the Rio de Janeiro legal community. That was the opening and the flexibility of the oil and gas industry monopoly that became a monopoly of the Brazilian government. So we had the opportunity to get in touch with the people that were involved in this very early days of the oil and gas Brazilian industry. And we were invited to join a group of retired Petrobras lawyers that had been exposed to global legal community and global legal business. And until 1998, I had absolutely no perspective and no experience what would be a global legal issue. And that's the new thing. We learned that in oil and gas industry, legal issues were actually global issues that requested decisions that had global repercussions. Decisions were concentrated in a very few set of people, general counsels, CFOs, and in my industry, or the industry that I grew up, geologists and geophysicists, who are the magicians of the oil and gas industry. So in getting involved with this industry, we also observed that the community producing legal decisions and producing law, and that was a different experience as well. There was a kind of a strange animal called a JOA, Joint Operation Agreement, which is actually a simple joint venture agreement. But it was created a mythology about what the JOA was. But the JOA was an agreement of lawyers to create a global oil and gas law. So I saw the 5 minutes. I would need probably 50 hours to explain the story, but I'll try to do it in 5 minutes. So we learned that this community was not bigger than 150 people, making decision, creating decision, participating in the decision-making process. And we learned that as Brazilian, and in view of a center and not central relationship that had been established in the past, we very unlikely would succeed as legal entrepreneurs. So we took a decision. We should get closer to people who had tradition and reputation in that industry. And that's why we decided in 2001 to associate it with the Texas firm called Thompson & Knight, which is not a huge global firm. It was, at that time, 290 lawyers, but with a very good reputation in that industry. But actually, I repeat, was a global industry with a very concentrated decision process. At my time, there was probably 7 super majors. Now it's 4. So it's a second phenomenon that eventually took us to look deeply at the phenomenon of global business and global law, convergence. Companies are, unfortunately or fortunately for the capitalist progress, they are getting smaller. I mean, they are converging. This is a capital process. And that will beneficiate and make it easy for people each more time to get concentrated decisions. And to the extent that we make part of a global thing, and I would need more 5 minutes to explain what a global firm is. A global firm is not a global entity. A global firm is a community. It may be an entity, but it's not a legal entity. If you gentlemen and ladies, if you look at the at the public material of Mayer Brown, which is not Mayer Brown law firm, there's a clear statement that says Mayer Brown is a brand that operates on a global basis, but it's actually a joint venture of independent entities. And those independent entities are Mayer Brown UK, Mayer Brown US, GSM, Hong Kong entity, and Tao in Czechia. And there is a Brazilian firm being referred on global basis in that statement. And by chance has my name. And I think this is very important. This is the new thing, regardless some people think differently. I think that by doing this way, and without changing anything on Brazilian law, in this 10, 12 years, we sincerely believe that we did everything in the system and in accordance with the system, the legal system. We don't believe that getting associations or making associations make foreign lawyers partners of our partnership. This is, if you know a little bit of law, you know that member of a Sociedade de Advogados is who subscribes the partnership agreement. So, till now, we don't have any foreign lawyer signing this partnership agreement. Second, there's absolutely no interest in foreign lawyers in practicing Brazilian law. If you guys have an open-minded, you will know that nowadays, law firms in the United States, they are defendants on innumerable lawsuits because of malpractice. And one noisy example of malpractice is to practice a law that you don't know. So no foreign lawyer wants to practice Brazilian law and practice in Brazil. So this is a half a lie or a half a truth. Every half a truth is a half a lie. So there's no foreign lawyers practicing Brazilian law. There's no foreign lawyers working in Brazil. What is important at this moment is that those federations, because it's much more a sense of a federation, you get together and you render sovereignty, a part of the sovereignty, to work on an orchestrated basis. An orchestrated basis gives you the benefit to access infrastructure of information, infrastructure of sophistication, acceleration of your communication process with global clients, in a shortcut building process in a way to diminish distance between clients and lawyers on global basis. This is the sense we had. This is what we believed 11 years ago. And we knew that in a certain point in time, we would burden some people. We would burden because we started this company or this law firm because commercialization is a different principle in Brazil. We started this firm with 4 lawyers, and 10 years later, we created a group of 90 reputable, high-quality, and sophisticated lawyers that some of them have left our firm to be another reputable and honorable firm, and some of them left our firm and are playing major roles in multinational corporations like Vale do Rio Doce and other international firms. So, as I said, I would like to have 50 minutes to speak, but I don't have more time, so I would like to stop here. Thank you.
Thank you, Ivan. Now I will call Mihaela Papa, which is a postgraduate student at, actually a postdoctoral student at Harvard Law School on the legal profession program, and she will give us some ideas on building legal capacity and also can talk a bit about regulation in India. Thank you.
Thank you very much, Lucy. And thank you. Sorry? Oh, I should put it closer. All right, sorry. So thank you very much. I would like first to thank FGV for organizing this wonderful event, and it is an honor to be here. In particular, this is a very special time for me because I'm first time in Brazil. So this conference is the launch, hopefully, of my long-time engagement with Brazil. I would like to talk about issues that GLI project is researching under the legal capacity topic. That is actually a research track, and it can provide another perspective on this debate on what is going on with politics and politics when politics comes in contact with the legal profession and its regulation. So the topic of legal capacity examines how Brazil, India, and China participate in international dispute settlement. And in particular, World Trade Organization, international arbitration, and investment arbitration. And these are very interesting areas of legal practice, in particular because they are so new in these countries, in terms of just the fact that these areas are where usually we're like developed countries places for solving disputes. And the question that emerges is how to have a level playing field, how to have Brazilian, Indian, and Chinese lawyers at the same level with equal opportunities to win cases, and how to build capacity to ensure that. And of course, this is particularly highlighted given that the bulk of knowledge and expertise has been dominated in Western countries. So basically, the engagement of emerging powers, so I like to call Brazil, India, and China, starts with these institutions, with the opening of the markets, and with greater integration in the world economy. So what happens is that once they want to engage, they need to develop the basic capacity, like basic skills, to speak the language, to have the knowledge of laws, but also the idea of legal strategizing. So not only to know, all right, these are the laws, this is the economic analysis that tells us whether to bring cases or not, but also to know when to use the system for what, how, and how to make sure that the system, that actually the participation is sustainable. So this creates several implications for the legal profession. One implication is that the reliance on foreign lawyers in initial stages is necessary. And then another implication is that there is a parallel process of domestic entrepreneurship and domestic lawyers that are trying to build these skills and the platforms through which they are building these skills. So if we look at the context of World Trade Organization in particular, when Brazilian government becomes a member, actually it is a member of WTO, but in WTO dispute settlement, Brazilian government naturally the first priority is to win a case. And then the question is how much of a priority is to have Brazilian lawyers win a case for it, or is it willing to probably sacrifice winning of the case while training Brazilian lawyers to be able to win the case if the expertise is not there. And what we see in the three countries, in India, Brazil, and China, the approaches the government takes to actually engaging external assistance are very different. So in China, the legal team said, no, every single case, there needs to be one foreign law firm, one domestic law firm. There is no foreign law firm that will be hired unless domestic law firm is there. And this is immediate, like institutionalized way that you actually get the domestic law firm on board. And this is not the case in each one of these countries. So the question that this raises is how to, at the same time, win the cases, and then also to ensure the transition that basically you develop, you protect the infant industry, and you develop this industry over time. And this is not just for the purpose of, let's say, Brazilian lawyers or Indian lawyers, but it is for the purpose of the system, because if this capacity is there, then this increases the loyalty to WTO, makes the WTO more legitimate, so it's for the benefit of all. And then another question is with investment arbitration. So all of the countries in terms of general arbitration have started breaking barriers in terms of use of commercial arbitration and have developed a lot of expertise. I think Brazilian lawyers in particular, how well they're equipped in ICC. So, and then also there are efforts to have some political ambition. Like, for example, Indian former law minister wanted to make India the center of arbitration. And that was a grand political ambition. But if all Mumbai lawyers want to take their cases to Singapore, and they prefer Singapore for neutrality, efficiency, and all other issues, then there is a little bit of a disconnect. So there is also a question of what is political ambition and what is actually the practical reality. In terms of investment arbitration, this is something that's just now starting with the first cases with China at ICSID, International Center for Settlement of Disputes, and with India, the cases, so it's just too small of a number of cases to draw any conclusions of what is going on. But more generally, when we look at the issue of these issues from this perspective, where actually foreign lawyers are needed to start with, it becomes illustrative of larger dilemmas, how to produce what people call now, in fancy language, smart globalization. And this smart globalization means how do you make sure that there is economic opportunity? This is why everybody is in the globalization business, to have the opportunity. But also how at the same time to protect sovereignty, and also how at the same time to ensure democratic decision making. And these three things are very difficult to balance. So this is like an ongoing negotiation process. And the way I see the project, as Professor Wilkins indicated, is every good negotiation needs objective criteria. And a lot of negotiations that have been going on are without objective criteria. What is actually going on? How can we, for example, in the WTO case, how do we know, like sector by sector or case by case, how certain law firms were selected? Was that because of expertise? Was that because of networks? Was that because of something else? So understanding basically what are the data, what is the knowledge, and then having the ability to describe what is going on, analyze and explain is very unique in terms of contribution to the overall debate. And thank you very much. I didn't now talk, I think, how much time do I have about?
You have 3 more minutes.
3 more minutes. So I think it's a little time to start the India regulation, but probably we can talk about it afterwards. We did a paper on globalization on the Indian legal profession, and one part of the paper was how the process of how the relationship between foreign lawyers and domestic lawyers has been negotiated, both like on the litigation side, both on like what are the legal cases, but also on the political side, and how these two processes worked in parallel. So, thank you.
And now to close the presentations, I would like to invite Ariosvaldo Matos Filho, who is the former dean of and founder of FGV, and from Matos Filho, Veiga Filho, Marrei, Júnior e Quiroga.
Thank you. Well, first, I'd like to make some disclaimers. I don't practice law anymore. I have the privilege of avoid clients. I believe that after some age, you must stop and do things in life that you ever want to do. So in the 1990s, well, I have been teaching at Vargas Foundation since 1969, and in 2000 I received an invitation from the Getúlio Vargas Foundation if I would like to help to create a law school, and I said yes. And then I took a leave of absence by 11 years because it was impossible to create a law school requiring full-time professor and full-time students if the dean was not full-time. And besides, because I believe that if we want to do a good job, it must be a full-time job. The second disclaimer is that after some age, I learned that it's much more important to listen than speak. Listening, we can learn. Speaking, we can say something that could be not useful. I agree with David Wilkins, as I used to call him last night, David W. and Dave G. That this is a neutral forum. A law school, the university, has a job to provide ideas and discuss freely ideas. As a law school, we have no commercial interest in this discussion. but we have a deep interest on the results, so we could be prepared to produce better lawyers to our country. Also, I agree with José Luis, CISA's president, that globalization does not affect all the lawyers. Indeed, it affects a small portion of lawyers, but with huge economic power on both sides. So I would say that this is not a fight between angels or Boy Scouts. Everyone knows exactly that they are fighting for money, for prestige, and for money. So what would be the interest of a law school in being part of this program? Because this program has the ability to produce data that no one has yet. And this data will show some paths to follow to form better lawyers. This school was formed with an idea that it was not my idea, but was David Trubeck's idea. Can I say when? 1966. No. Well, this idea started in the end of the 60s, the Túlio Vargas Foundation in Rio. So that's why we are involved and happily involved with both Davids and with Harvard, and because it will show us how the legal part of the legal world is changing and what sort of lawyers this part will demand. It shows us another thing, that law schools probably in Brazil, as we have too many law schools, they're going to shrink as time goes on. And probably law schools will get more specialized in different fields of law. In a law school as small as this one, because we admit only 50 students per year, and that was on purpose, we have a concept that we are able to teach not only the science that will help lawyers such as corporation taxation, litigation, and so on, but as they are full-time students in the first 3 years, we are able to teach them the fundamentals of law, such as philosophy, sociology, history, and so on and so on. 1 year of legal English and so on, and at the same time teach them the abilities that will provide to them a profession. So, again, not talking too much, but listening as much as I can, I would say that this research is quite important because even if we like or dislike, Brazil is becoming increasingly involved in the world. So it is a fight between foreign law firms and Brazilian law firms. It's a fight between Brazilian producers of orange juice and Americans produce of corn, gasoline, and the French producing, I don't know, chicken. So we are here now in this debate that is part of a huge debate, economic debate. And as I believe and said before, it is not a fight of angels or Boy Scouts. but it's a fight of people who knows how to defend their interests. So we must create, on the other side, people also with the ability to defend their own interests. So that's why I'm trying to learn what you are doing, so we can suggest to this law school in the future what should we change, or what should we keep, or what should we give more emphasis. So that's the purpose of my presence here, and I would like to not only compliment both the three, Double Day and Luciana, for this wonderful work, and I'm eagerly waiting for the data and the results so we can apply here in our school and propose to other Brazilian law schools. Thank you.
Thank you. So now it's open for questions and debate.
Hi, my name is Paulo. I'm working with Professor Frederico on the research about the regulation of legal profession made by the Brazilian Bar Association. And since this is the object of the study, I would like to ask Professor Mr. Tawil. We would like to understand a bit about how this association works. You have just told us that you do share procedures and the way that you manage the firms, but we'd like to know if what else, and also some clients, but what else do you share? Do you share any kind of revenue? How is the association made between the Brazilian member of Meyer Brown and the other member of it in the world?
Excuse me, your name is?
Paulo.
Paulo. Very glad with your question, and I'm very happy in trying to respond if I can. While responding to your question, I would like to make a very brief typology or classification of associations. Okay, we could divide in two big groups. I could call in light associations, or associations that provokes or creates soft links, and associations that create strong links. The associations that create light or soft links are those type of mundi lex or interlaw, or that actually are a convention of the so-called independent firms. Independent firms are in U.S. the smaller firms, and all the rest non-U.S. firms, like Brazilian firms used to be in the past. I think that Brazil is time of creating global laws. And what I would call the strongest links associations are, to make a second analogy, instead of dating with a lot of people, you decide to fiancé and eventually marry with only one firm. In terms of strong links associations, what I could learn is that there's two major types in place. Central expansion or central expanded firms, international firms, that try and usually trade and sell the concept that we are a firm and we are not a franchise. I've listened to that several times in the past. And it seems to me that this model is not actually succeeding in the global competition for legal business. The second type is it's much more a federation style that recognize that there must be autonomy because law is substantially a local cultural phenomenon. So in this sense, there's other global firms that actually represent a combination of atomized local law firms that orchestrate and share part of their lawyering or their legal activity. I would tell you that making part of association of a strong, that creates a strong link, it's making part of a party, you know, a partido. So it's much more in this sense. What we share technological tools, we share visions, we share what I think it's very important, some universal values, like integrity, like quality, like efficiency, including economic efficiency. We must be profitable, and we exchange information about how to maximize our economic efficiency. So we learn how to better manage our profession. We learn how to better manage our real estate facilities, our technological tools, so on and so forth. But more importantly, we share very important human values. I'll give you an example. To be part of an association like this requests you to accept concepts like that are crystallized in legislation like FCPA, for example. Being connected to a global law firm that interrelates or interacts with the U.S. jurisdiction make you eventually possibly liable if you don't, you know, if you cross those lines. And this is very important. This is very important. This is and that creates certain signals. They are very, very attractive for global clients. And that creates an advantage for you. And I don't think that this is, it turns legal practice as a merchandise, mercantilização in the sense that has been discussed in the current debate. And last but not least, I mean, we share loyalty in terms of a conflict of interest. Of course, there's a lot of complex discussion about what is a legal conflict, what is a conflict in a multi-jurisdictional environment, okay? And we several times we discuss with colleagues in this network of lawyers. But it's very comfortable for clients to know that, you know, the client represents me in one jurisdiction is not actually suing one of my subsidiaries in that same or another important jurisdiction. And so in this sense, you harmonize your position in the market in this orchestrated sense. I'll make a statement that is very, very, very important. It's our vision that Brazilian regulatory market is perfect. It allows the entering of Brazilian law firms and Brazilian lawyers into the global system. And you don't, in terms of globalization, you don't have to make part of an association with any other global firm to be a global lawyer, to the extent that you touch global problems and you interact with the global problems. But you can make an election because is that the way that you vision and you envision and you see the future of your law firm. You can make an election. And we sincerely believe that this is a business decision. This is a private management decision to be allied or not with the global law firm. Understood a global law firm as this entity and not actually a legal entity that I make a reference in the past. And of course, this interrelates with the current discussion, under discussion in São Paulo OAB. And it's very important to remark that OAB is not the São Paulo OAB, which is an important part of OAB. And I would like to remark something that I wrote in an article, that all this regulation discussion affects no more than 3,000 lawyers that practice business law, some of them doing global business law, some of them doing local business law, while the College of Lawyers in Brazil, it's made of 700,000 lawyers. So most of them practicing a different day-to-day family law, real estate law, and whatever law. So, but of course, probably 90% of the value of this market is concentrated in this very small portion of the community. And when I said that the local regulatory market is perfect, I think the discussion of a presence is not a discussion that should affect OEB. This discussion is a legislative discussion, because so far, what the regulatory market proposed is that a law firm in Brazil, a sociedade de advogado, is a very strange animal, because it is a society for only purpose of sharing costs and making possible lawyers to practice law, because it's crystal clear in the legislation that the law firm does not practice any legal act. I mean, I have to be technical now, but ato privativo de advogado is only performed, the legal act is only performed by individuals. And law firms does not practice law. It's crystal and clear in our law. So, whatever you decide to do with your money, it's a business decision, and that does not have nothing to do with the legal praxis. It has to do with what lawyers as individuals want to do with their money. But being transparent, there's no legal vehicle today to share any revenue or profit. And you might ask me, why you do associations? Because of the cross-selling. Cross-selling is the most important issue in an association with an international firm. And I may be wrong, but I don't think I am. Most of the successful Brazilian firms during the 90s and the early millennium had in international firms, if not the major source, probably an important source of their revenues, receiving referrals from international law firms. And again, I use my funny example. It's an issue of dating or getting married. I mean, you can work with multiple law firms outside of Brazil, or you can elect one of them to be your partner, your business partner. And should the loyalty and trust that derives and emerge from this decision, that opens you the opportunity to share other beneficial components of this structure, like technology, like softwares, like experience, like the opportunity on a very easy way to send your Brazilian lawyers to be trained, to have work experience outside of the country, to have access to very important worldwide reputable institutions, and so on and so forth. But not extending too much, because I think our other colleagues want to make points on that. I would say that we share substantially this. As a Brazilian Sociedade de Advogados is a partnership of individuals. So it is impossible under the legal perspective to have a capital control. So equity, it's 100% owned by Brazilian lawyers, who are the only lawyers who practice Brazilian law. So there is no sharing of profits. What we share are business opportunities. If we have an important client doing business abroad, we will refer our firm, let's say, in the context that we referred. If my partners outside of Brazil have a multinational client or a giant corporation that wants to do business in Brazil, they will likely refer us. But this is not a stone. I mean, and I can disclose examples. I have colleagues from Mayer Brown in the U.S. working with Lobo de Riso and not with our Checker. I have a partner in São Paulo who is working at this moment with Simpson Thatcher and not working with Mayer Brown. Why? Because the client wanted this way. So it's a client. In the end of the day, it's always a client decision. What you offer is a shortcut, as I said. What you offer is the alternative of a one-stop, one-shop. But this is a client decision. One-stop, one-shop is something that only started to make sense in the context of a global economy, an economy with information, capital, people. They circulate with the speed of the internet. And so probably we are connected with this vision and nothing else. But I hope I have responded and probably talked too much.
We have 10 minutes, I think, right, Luciana? 10 minutes. and then we're having lunch. So if someone has any other remarks, we still have 10 minutes to discuss.
Well, if anyone has remarks. One thing that I learned here that I never thought about, that would be quite important to our law school, is to invite the in-house lawyers to have in-depth discussion with us, because they represent not only important segment, but also they can give us some light on the research that you are doing, but we at the school didn't know. So it's one thing that I learned today that could be quite important was, I don't know who is in charge to, but I believe that we should organize a round table inviting chief counsels in-house.
Trubek?
So there's been a lot of emphasis in terms of understanding the project of the need for data, and I think that's very important. But when we talk about data, we're not just talking about some numbers. We're also talking about principles. I think that it's important when you begin. I listened to this debate, to which I'm relatively new, and I'm asking myself, okay, I mean, obviously, as Ari says, there are a lot of strong economic interests at stake in deciding how to draw these boundaries. So there's a we're now in a, let me put it this way. Throughout the world, the boundaries are being rethought. And this is leading to a lot of tension and debate. The boundaries have to be rethought because the world has changed, and the boundaries are either old boundaries that don't fit or new boundaries that are being proposed to try to deal with a new situation that had, okay. So this whole boundary settlement, to some degree, the rhetoric that's used, and lawyers are very good at producing rhetoric. This is something that actually law schools have known well before globalization, is to how to train lawyers in producing lots of rhetoric, right? This is a skill that I think, actually, Brazilian law schools are particularly good at. And there's a lot of rhetoric, but the rhetoric doesn't seem to me often to have very much to do with the principles that should be used to settle these issues over boundary setting. That is, there are principles that we should be thinking about, and some of them have been discussed. So there's the principle of capacity building. So one of the arguments for some restrictions, on the one hand, foreign lawyers say in Brazil or anywhere, is we need to build up our domestic capacity. That the Indian law firms made that argument. We had the meeting like this in India, and the Indian law firms, who were very much in favor of eventual opening of the market, just made the argument, we need more time. And capacity building is extremely important. But, of course, capacity building can be done in more than one way. And Mihaela did not mention, but I think we should all be aware that Brazil is one of the leaders in capacity building for international legal skills in the WTO. That is, Brazil has had a government program to build its capacity of its lawyers and its government lawyers and private lawyers and government officials to successfully litigate in the WTO. So capacity building has a sort of a two-edge. There are two ways to deal with it. So capacity building is a principle, and we should look at questions of boundaries in terms of how do we build capacity in countries that didn't have this capacity simply because it wasn't necessary. It wasn't necessary to do a lot of this, kinds of issues. Okay. A second principle, it seems to me, is client service. What is the best way to provide the information needed by the clients? That's what the general counsels can, the in-house counsels can help, because they look at it from the point of view of the client, and they're the ones who have to do something that is obviously central to this whole debate, which is the integration of multiple types of legal knowledge, both multiple legal knowledges within a given jurisdiction, so issues that will involve tax and antitrust and oil and gas law or whatever, that all Brazilian don't need to know anything about anything else except Brazilian law, but you still have to integrate these things in order to make a decision. But then you have to integrate it with, could be Texas law for all I know, right? Or some international regulation, the WTO or whatever. So you have this two dimensions of integration: horizontal within the country and vertical, multi-level, and the global problems usually, or let's say, the global problems frequently involve both horizontal and vertical integration, and somebody has to do it. That doesn't mean that there should be one stop, one shop. That may not indeed be the best way to do it. This is what we learned about unbundling, that it may be with technology and specialization that it's better to unbundle it, but then somebody has to bundle, because in the final decision the company has to decide whether to build a refinery or buy the company, and that means that at some point all of this comes together. So it seems to me that client service, that is the best way to put the information together that the client needs to make the best decision, is a second principle. So we have capacity building, we have client service, and I'm sure there are others. So my general point is, as we think about this, and we think about data, we have to figure out data for what. And these kinds of principles seem to me we need to be talking about, and we need to be talking to the different constituencies or stakeholders in this, because it isn't just the lawyers, and indeed, it shouldn't be just the lawyers. It should be the whole set of stakeholders who have an interest in how the boundaries are drawn and redrawn in this global era.
I just want to add one more point, and in this point disagree with Ivan Tawil. I think that to discuss the regulation of legal practice is also involved legal education, and we have to be prepared to discuss this. This kind of discussion is not a reality here in Brazil yet, but we have to be prepared to discussion who is forming lawyers. It is a foreign law school, it's a national one, it's a foreign law school here in Brazil, it's our international programs, because this involved who can get the bar or OAB permission to lawyer. So I think that discuss regulation is not just discuss the legal practice or the association, the Brazilian lawyers with foreign lawyers. It's also a discussion about the legal education and who is forming this global lawyer, or just the lawyers that we need. So we have to, I think that this discussion with OAB and the regulation involved the association with the foreign, the new kinds of products or service provided by the lawyers, and also the legal education. And this is one of the goals of the GLE project, is to produce data about these exchanging programs and this kind of different legal education. That's not the traditional one.